Now, the reason why I show you this AIR form for tenant estoppel certificate is because that's the easiest one to use. If you don't have anything better, use this one. But if you have something better, you might want to consider using it. Now, once I finish teaching you guys all the different standard forms, then in the future, you are going to be seeing more and more custom forms from the law offices of Tenant. Right now, at least if you don't have anything better, just use the standard forms. We might improve on some of these forms, so those will be the custom forms that we'll use in the future. Now, you see this one here, it says Tenant Estoppel Certificate by Lessee. Lessee means tenant, right? Okay, so, and the form itself is actually explanatory. You have the date of the lease, and it's between, you put in the name of the lessor and the name of the lessee, and then you put in the property address, right? And sometimes a lease can be amended. If a lease is amended, you want to put in which was amended, and then when you want to put in the amendment date over here, and then it also indicates who the guarantors are. You want to put in the guarantor over here, okay? All right. Now, the standard things that we ask for in the tenant estoppel certificate, we usually, if I'm a listing agent representing the seller, I will ask the seller to provide me copies of the leases that have been signed. For example, if I'm selling a shopping center in San Leandro, actually last year I actually helped a client sign, I wasn't the agent, but I was just an attorney. I actually helped a client sell a commercial real estate in San Leandro. They have about 10 different tenants at that location, and these leases are like 20 years old. They are really, really old leases. And we had to do tenant estoppel certificates, okay? I can't remember what forms we used because I think I let the agents worry about the forms. My job was just to review and not to prepare the form. So we always ask the landlord to provide copies of the leases. So we will just attach copy of the lease and have the tenant sign this tenant estoppel certificate, confirming that these are copies of the leases that the tenant signed. And that is very important. So when you do a tenant estoppel certificate, look for the copies of the lease, attach them as an exhibit. Okay, in this case, we call it Exhibit 1. Attach the lease as an exhibit and have the tenant sign the estoppel certificate. Now, if the tenant has a different copy of the lease, now we may have an issue. But if the tenant has the same copy, then the tenant will just affirm that this is actually a true and correct copy of the lease. Okay? And then you also, now if you have already attached copy of the lease, if the tenant has no objection, he'll just put in none over here. Okay? Put in none. Do you leave it blank for the tenant to fill it out? Or do you want to type in none for him? If he agrees, then it's okay. It benefits you. Of course, if he does not agree, he'll just say, can he remove none over here? Because that's not true. I have exceptions. If he has any exception, the word none should be deleted and be replaced with some other information. Okay, he may not agree to everything that you put on the tenant estoppel certificate. But on the other hand, if you put in none on this and he doesn't realize the exceptions, then it's too bad for him. He's bound by the tenant estoppel certificate. So I think if you're a tenant, you got to be careful about signing tenant estoppel certificate too. If you are not careful and you're a tenant, you sign a tenant estoppel certificate that is incorrect, that information is binding on you. So if you regret later on, it's too late. So tenants should not simply sign tenant estoppel certificate without checking the information. You know, I've had tenants, clients who will come to me to review the tenant estoppel certificates because they do not want to make a mistake on signing the tenant estoppel certificate. There are tenants that are very careful in signing tenant estoppel certificate because they don't want to make a mistake. They'll rather have an attorney check it. Okay? I do provide that service once in a while. Not my favorite service, but I do provide it. Okay? And then here you will talk about what's tenant's view as to the commencement date of the lease. Because sometimes tenant's view may be different from landlord's view. So if I'm the listing agent, when I prepare the tenant estoppel certificate, the information that I put in, it's always from the landlord's view. It's never from the tenant's view. I always put in the information from the landlord's view. So if everything that's on the tenant estoppel certificate is from the landlord's view, and the tenant happens to agree to everything, the tenant cannot regret later on. Too late to regret if he signs it. It is binding on him as far as the buyer is concerned. If I'm a buyer, I want to review all of the tenant estoppel certificates to make sure that I can live with the information. Now, you notice that it talks about the rent amount, the lease periods. It talks about the rent amount. You know what pass-through is? Pass-through are just expenses that the landlord incurred, but that was passed through to the tenant. That's what we mean by pass-through. Okay? It's just some expenses that the landlord incurred, but that can be transferred to the tenant. Of course, you cannot have a tenant estoppel certificate without mentioning the security deposit. So a good tenant estoppel certificate would include a space. Now, usually, if I'm the listing agent, I will simply ask the landlord, how much security deposit has the tenant paid you? And just fill in the blank over here. Okay? And then on number 5, the lease has not been modified orally in writing. Now, usually, if I'm the listing agent, I'll type in none over here. Because you know why? If I ask my landlord client, my seller, has the lease been modified? If the answer is no, I want to put in none over here. But that's from the landlord's perspective, not from the tenant's perspective. Okay? And then on number 6, the improvements and space required to be provided by lessor have been furnished and completed in respects to the satisfaction of lessees. Now, what this one means is, you know, often when a tenant decides to lease a space, the tenant will ask the landlord to make certain improvements. If the tenant asks the landlord to make improvement, we want the tenant to put on the tenant estoppel certificate that the tenant was satisfied with any improvements that the landlord has made for the tenant. Because we don't want to, if I'm a buyer, I don't want to have a situation where in the middle of a lease, suddenly the tenant say, well, you know what, the previous landlord said he was supposed to do X, Y, Z for me, but I wasn't satisfied with it. Now it's your obligation to satisfy this. Okay, so that's why number 6 is for. Basically, to find out from the tenant, was there anything that the landlord promised to make for you as far as improvement that you are not satisfied with? So the tenant have to state, yeah, I'm not happy with this or I'm not happy with that. So if it's none, then as a buyer, I never have to worry about this anymore. Okay? All right, next. Lessee has no knowledge of any uncured defaults by lessor or lessee under the lease. This is also useful because you know why? Because sometimes in a commercial lease, the landlord may have certain obligation to do certain maintenance, and if the landlord does not fulfill their obligations, as a buyer, I want to know about it. because one of these days the tenant can come back to me and say, did you know that he previously promised this, or he previously agreed to do this, but he didn't do it, now it's your obligation. And then suddenly the tenant show a paperwork, which the landlord never showed you, that has both the landlord's signature and the tenant's signature. See, he signed this thing. He said he was going to replace this XYZ, but he never did. Now it's your obligation. Okay? So that's why you want to ask questions like that. If the tenant says none, we're all set, right? As a buyer, you're all set. Okay. All right, number 8, it says, lessee in full and complete possession of the premises and has not assigned or sublet. Now, this is also important to the buyer, because as a buyer, if there has been any sublease, I want to know about it. I want to know who the sublessee is, right? So you want the existing tenant to confirm that they have not assigned the lease to anyone else, or they have not sublet the property to anyone else. Okay? Number 10. Lessee has no knowledge of any prior sale, transfer, assignment, or encumbrance of the lessor's interest. Now, this is basically to make the buyer feel comfortable that the seller has not sold the interest or encumbered the property such that this encumbrance will become the buyer's liability. So as a buyer, I want to see the word none over here. Okay, if it's not none, then I want to know what it is. Okay, and then as a buyer, I also want to know if the tenant has made any alterations to the property. So if there are any alteration, why is it that as a buyer, I want to know if the tenant has made certain alterations? Reason is, if I'm a buyer, if tenant has made certain alterations to the property, I want to know, one day when the lease is expired, does the tenant have an obligation to restore it? Remember, if it's not mentioned, trade fixtures are removable by the tenant, correct? And trade fixtures, even though they are removable by the tenant, if tenant damage the property as a result of removal of the trade fixtures, tenant has to make repairs. However, on the other hand, if it's not a trade fixtures, if it's just fixtures that are installed by the tenant, if they are fixtures, normally, if nothing is mentioned, the fixtures stay with the property once the tenant leaves. But what if I'm a landlord? I don't want to keep these fixtures. I want tenant to take responsibility to remove all fixtures, whether it's strict fixtures or not. I need to know, because if you know, it's an expense for me to have to restore it, because let's say, for example, this particular tenant uses the warehouse for a certain unique purpose, and once it's gone, that unique purpose is not, will make some of the improvements not useful for my future tenant, then I have to restore it. It's an expense to me. I want this expense to be by the tenant and not by the landlord. So I need to know what kind of improvements the tenant has made to the property, correct? So that's why it's important that I know this thing. So hopefully it says none over here, right? Okay. And then if it doesn't say none, then I want to know. Now, as far as guarantee goes, if the guarantee is no longer good, or there has been change of guarantee, as a buyer, I want to know. I want to know what my risks are. What if the guarantors are already dead? And the previous landlord did not do anything about getting new guarantors. So I need to know, right? Okay. Next. Oh yeah, if the tenant is in bankruptcy, I want to know. If I'm a buyer, right? I'm buying a property, and the tenant just commenced Chapter 13. As a buyer, I want to know, because that could affect my decision whether to buy this property or not. I mean, just imagine I just open escrow, and then in the middle of the escrow, the tenant files for Chapter 13. Should I cancel the escrow? Maybe I should, especially when this person is a key tenant, or maybe the only tenant. If I close escrow, Chapter 13 doesn't help me as an investor. So I need to know if the tenant has filed for bankruptcy or not, right?
But if he filed bankruptcy after you close escrow, then we have to stick with that.
Then you're stuck with it.
Okay.
Okay, then you're stuck with it. Okay, anyway, here it says additional items. Now, if I'm the person, I know Tiffany, some of you may not know that Tiffany Garrick is our in-house counsel. We do have a legal department. So if you ever talk to your clients, mention to your client that we do have our own legal department. And this Tiffany Garrick, she's the attorney in our legal department. Sometimes I ask Tiffany to prepare a tenant estoppel certificate. And one of the things we would add, if it's a custom tenant estoppel certificate form, we always ask if there are any options. And we always ask if there's any right of first refusal, okay? And make the tenant tell us if the tenant has any options. Do I have to break it down into option to purchase, or option to extend, or option to renew, or option or right of first refusal? Now, options and right of first refusals, technically they are different though. But options are options, whether it's option to renew or option to purchase. So I can kind of group all the options together. So I ask the tenant on the estoppel certificate, do you claim any options, or do you have any options under the terms of the lease? And have the guy state none, okay? If it's none, then the guy cannot later on claim any options against me as a buyer because he's stuck with his answer, right? I can also ask the tenant through the tenant estoppel certificate, and I can ask him, do you have any right of first refusal or right of first offer? I can do that. And then have the guy answer none. Then he cannot later on come back to me and say, well, I have a right of first refusal, or I have a right of first offer. Okay? So I think you are not limited to what's available on the standard form. But if you don't have anything better, standard form is the only form you're going to use. But I'm just trying to tell you that there are certain things that may be important to put on the tenant estoppel certificate that are not on the standard form. Now, why is it that you ask me, why is it that when they design the tenant estoppel certificate using air forms, they didn't think about the options of right of first refusal? Frankly, I don't know why, although I do think that those are even more critical than the amount of rent the guy is paying, because given the example that I gave you earlier, you know, sometimes it could be a few $100,000 in losses to the buyer if you have things like right of first refusal or options and things like that that the buyer is not aware of. Think about it. If the guy has 2 5-year options and you didn't know about it, okay, that would be awful, right? Okay, but I think the options to renew or extend are more common. You know what they are. But the right of first refusal is less common. So sometimes it's good to know if the tenant has a right of first refusal or not. Now, for those of you that did not attend the last class, right of first refusal means this. It means if I'm a tenant, I own a right of first refusal under the terms of the lease, and if one day landlord decides to sell the property, if I'm the listing agent and I represent the seller, and I notice that there is a right of first refusal, I, as the listing agent, needs to submit any offers that I receive from prospective buyer to the tenant to let the tenant decide if the tenant wants to match that offer or not. Let's say, for example, the tenant has a right of first refusal, and I receive an offer for $6 million. That offer will be presented to the tenant, and the tenant has a certain amount of time to decide if the tenant wants to match the price and be a buyer for this property. That is a right that the buyer has. Now, assuming that you did not discover about this right of first refusal, and then you put the property on the market, you list it for, let's say, 6.5, and then there's an offer that came in for $6 million. You did not speak to the tenant, not realizing that the tenant has a right of first refusal. You sold it to this buyer for $6 million. You have just bought yourself a lawsuit because the tenant said, "How come you didn't come to me? I have a right of first refusal." You sold this property to this buyer. Now, sometimes you get lucky. You discovered it before close of escrow. Now, what happens if you discover before close of escrow? Who is more likely to sue you, the tenant or the buyer?
The buyer.
Why is it the buyer more likely to sue you? That's right. He has a binding contract, and now the seller is in breach of the contract. And if the seller gets sued, who gets sued? The agent.
Oh.
You, the professional, how come you didn't know about the right of first refusal? Right? How come?
The seller, you didn't tell me before. Or the seller, you didn't tell me before.
And you know, that's why I think it's important that everyone knows what the tenant estoppel certificate is. Okay.
So if after the escrow, then the problem is suing the seller.
Yeah, that's right. Okay. Now we don't have time to do assignment today. Maybe next time we'll cover assignment. Actually, you know what? Assignment is so short, might as well go ahead and finish it. Now, assignment is related to leases, right? So if you ever have a situation where you have assignment and assumption of lease, right? There are two types though. You got the assignment and assumption of lease and consent of lessor, and then you got assignment and assumption of lessor's interest in lease. They are two different forms. The first one refers to a situation where the tenant wants to assign the lease to someone else. The second one refers to a situation where the landlord is selling the property and wants to assign the lease to someone else, or simply wants to. If you look at the first one, now this is the one where the tenant wants to assign the lease to someone else. It's a very simple form. So if you represent the tenant or even the landlord, you just go and fill in the blank. Who's the assignor? The assignor is the tenant. Who's the assignee? The assignee will be the new tenant. And then you fill in the date for the lease, and then you put in the lessor's name over here because it says lessor, and then the property address you just fill in here. And then the effective date of the assignment, you just fill it in here, okay? And then you get everybody to sign. And assumption of lease. The two of them actually goes hand in hand. So if you have an assignment of the lease, you always have the assignee. Assignee is the new tenant who's going to assume the lease. So yeah, this form is actually very useful. You might use it in the future. If you ever have an assignment situation, there is a standard form that you can use, okay? And then for the other situation, let's take a look at this form. Now this is slightly different. This is assignment and assumption of lessor's interest in the lease. The top part is the same, but the bottom part is slightly different though. Let me ask you this. On this assignment and assumption of lessor's interest in the lease, who is the assignor and who is the assignee? Assignor is the landlord. Assignee is the person to whom the landlord is assigning the lease, usually a buyer. Okay? But usually you don't really need to sign this unless it's not a purchase situation. I don't think you ever need to use this form if it's a purchase situation. So I think it may be one of those situations where it's not a purchase. However, even if you have a purchase situation, you can go ahead and fill out this form, and the reason is, you look at number 2. Number 2 says assignor assigned to assignee the security deposit. Here it clearly spells out how much of the security deposit that the tenant paid that is being assigned to the new owner. Okay, and then basically the old landlord will sign this, and then the new landlord will sign this as well. The new landlord is known as the assignee. It says assignee hereby accepts the above assignments and assumes all of the rights and obligations of the lessor. Right? So it is a different form. Okay? Okay, that's it for today's class, and thank you all for coming.